Good morning and welcome to the third meeting of the Health, Social Care and Sport Committee in 2025. I've received no apologies for the meeting. The first item on our agenda is consideration of a negative instrument, the Bread and Flour Amendment Scotland Regulations 2024. The purpose of the instrument is to introduce the mandatory fortification of non-wholemeal wheat flour with folic acid. This is intended as a public health intervention to work alongside other public health measures to help reduce the incidence of fetal neural tube defects in Scotland by increasing the dietary intake of folic acid and therefore blood folate levels in women of childbearing age. The amendments specify that mandatory flour fortification will take place by requiring that non-wholemeal wheat flour be fortified with folic acid in the specified quantities. The instrument amends the Bread and Flour Regulations 1998, or the 1998 regulations in Scotland, to introduce the mandatory requirement for non-wholemeal wheat flour to be fortified with folic acid, to amend the required quantities of fortificants which are currently added to flour, and to introduce an exemption for these requirements for small mills, and to make some other technical amendments. The Delegated Powers and Law Reform Committee considered the instrument at its meeting on the 14th of January 2025 and made no recommendations in relation to the instrument. No motion to annul has been received in relation to the instrument. Do members wish to put any comments on record? I propose that the committee does not make any recommendations in relation to this negative instrument. Does any member disagree with this? Thank you. The second item on our agenda is to take evidence from two panels of witnesses as part of our scrutiny of the Assisted Dying for Terminally Ill Adults Scotland Bill at Stage 1. By virtue of Rule 12.2.3a, Liam MacArthur MSP is attending the meeting today as the member in charge of the bill. Welcome, Liam. We begin today's scrutiny of the bill by taking evidence from representatives of the Crown Office and Procurator Fiscal Service and Police Scotland concerning law enforcement considerations in relation to the bill. And I welcome to the committee Laura Buchan, Procurator Fiscal Policy and Engagement, Andy Shaws, Head of Scottish Fatalities Investigation Unit from the Crown Office and Procurator Fiscal Service, and Steve Johnson, Assistant Chief Constable at Police Scotland. And we'll move straight to questions, and Emma Harper.
Thank you. Thank you, Convener. Good morning to everybody. I'm interested in exploring issues around the current law. And in the policy memorandum, it talks about how the member in charge believes that the current legal position is unacceptably unclear and there is currently no specific legislation in Scotland which makes assisted dying a criminal offence, yet it's also possible to be prosecuted for offences such as murder or culpable homicide for assisting the death of another. So I'd be interested in what you think, what your assessment is of the extent to which the current criminal law is clear or not, and to what extent there's a 2016 case of Ross versus the Lord Advocate which made the position clearer. So I'd be interested in just exploring issues around the current law.
Thank you. Good morning. It is recognised that this is a particularly difficult and emotive area of the law that raises important issues, and therefore it is quite proper that any proposed change to the law should be a matter for Scottish Parliament. It's the job of prosecutors in Scotland to apply the laws that are there. But if it assists, I can talk through the current process in relation to assisted dying in Scotland. As the committee will be aware, in the documentation that I know the committee have before them, there are historical differences in the way that the law has developed, and in fact the criminal justice systems have developed between England and Wales, which makes our systems quite distinct. Suicide is not a crime known to Scotland, and there is not a distinct crime in Scotland of assisted suicide. In contrast, there is a statutory offence in England and Wales of assisted suicide, but the Suicide Act does not apply in Scotland. In Scotland, if someone does assist another to take their own life, such cases would be reported to the Procurator Fiscal as a deliberate killing of another and would be dealt with in the law relating to homicide. under the law of homicide, we would have to consider whether there was sufficient evidence to determine an offence had been committed, that the individual was the perpetrator of that offence, and that the individual had the requisite intention to commit the offence. We would also, and I think in terms of the case that you referenced, Ms Harper, we would have to show that there was a direct causal link between the actings of the perpetrator and the deceased's death. So it would have to be a significant contributory factor to the death. So there is a considerable amount of case law around causation and contributing factors, which would require to be really carefully considered in the circumstances. And we do say that in every case, we have to consider all the facts and circumstances that are before us and the evidence with the cases that are reported to us. Once we've reached that stage in the process, we would have to consider whether any prosecution would be in the public interest. And the criteria for deciding whether a case should be prosecuted is set out in the Prosecution Code. And the Prosecution Code is an available document on our website. There is, the taking of another life is one of the most serious offences in Scotland. So there is a high public interest in prosecuting aspects of homicide where there's sufficient available evidence. Ultimately, if we decided to prosecute it, it would be a matter for the jury to decide whether the standard of proof had been reached and to determine whether somebody was guilty of culpable homicide. And it would be for the court to ultimately determine the appropriate sentence, taking into account any mitigatory factors that exist. So that's the current law in Scotland in how we would consider cases that were reported to us in assisting in suicide.
Okay. I'm just also, and anybody else can come in if you choose as well, does the bill as it's laid out right now propose there would be a pathway for somebody to end their life without others then being prosecuted? And does the bill interact with the current law in a way which will facilitate prosecuting offences around suicide and assisted dying, which is not covered by the requirements of the bill? Because this bill is about somebody choosing to have to be assisted to end their life if they are terminally ill.
Good morning. I'm happy to answer that. There is a provision in the bill, obviously, that sets out there would be no criminal liability where someone has lawfully provided assistance to someone else to end their life. So that provision, the protection provided by that provision, would only therefore apply if that assistance was lawful. So I think the first thing that we would consider would be whether or not the process had been lawfully adhered to. And if the assessment was that it hadn't been lawfully adhered to, then the existing criminal law would apply to anyone involved in any potential offence or offences relating to that.
Okay, because I'm thinking about healthcare practitioners. I'm a registered nurse myself. I probably need to remember and say that. But yes, so it's for healthcare practitioners who are participating in the process of helping somebody in their life.
Yes, I think that's why it's important that the provisions are as clear as possible, not only for the benefit of those investigating any death, but obviously for the benefit of those who are seeking to follow the procedures in place. I think the greatest degree of clarity and certainty possible would certainly be welcomed by us.
Okay, thanks.
Brian Whittle.
Okay, thank you, Convener. Good morning to the panel. Coercion is one of the main issues that has been raised almost in every single panel that we've spoken to. But so I wonder what your considerations are around whether the bill, as it's written, is sufficiently clear to enable prosecution, and potentially could you maybe give us an idea of what kind of evidence you'd be looking for to be considered in this context? I suppose, given Mr Shanks, probably a good place to start with that. Can I ask you? Or Miss Buchan.
Probably for Miss Buchan in the first instance.
Thanks. Yeah, I think one of our observations in relation to the bill is particularly around provision 61C, It talks about medical practitioners making an assessment about whether the person has been coerced or pressured. I think, as my colleague Andy said, clarity around what that would mean in terms of the process. What would a medical practitioner require to take into account to determine whether somebody has been coerced or pressured? I think that would be helpful in terms of the medical practitioner having understanding of what process they would require to carry out to satisfy themselves to that. And it is not clear from the bill how, if the medical practitioner has any concerns around coercion, how those concerns might be raised with the relevant authorities. There might be scope for disagreement amongst practitioners in respect of whether there is coercion or not. So it's something, again, I suppose one of the observations around clarity in terms of what do we mean by coercion and pressure. How would a medical practitioner determine whether there's coercion or pressure there? How would they intimate whether there had been coercion or pressure in the process for that to be considered? There is no offence of coercion in Scots law currently. It's more ordinarily discussed in the context of defences. And I suppose in terms of our own consideration, much would depend upon whether the coercion came to light during the process or if the coercion was raised by potentially another after the process had completed. And that would determine for the police and for the Crown how they would require to consider that in terms of the offences.
I suppose a supplementary to that would be if coercion is not currently an offence, presumably within the context of this bill, coercion would become an offence. And I think, one of the questions I would ask is, that we're asking the medical profession, who are not the legal profession, to make a judgment on something that is potentially breaking the law. Is that fair, Mr Johnson?
Yeah, from my perspective, we raised exactly the same issues, that this aspect of coercion or pressure. During the process, we would say exactly the same thing. If that gets referred to the police for an investigation, what's the scope and scale of our investigation and how would we report that to the Crown? The bill creates an offence at those stages. It doesn't seem to create the offence after the event, and that would be our primary concern, that after the event, a distant relative or somebody else, a third party, comes in and says, we believe there was coercion that has led to, where do we sit then? So we would say there would need to be clear guidelines for those medical practitioners that are making those statements, because in their statements, both the coordinating and the independent are both asked to declare at point 2 that they are not knowingly. So how do they know that? What's the nature of the questions? What's the nature of their inquiries with the individual that's in front of them around whether there's been a broad conversation between interested parties in their family, for example? So we'd be really keen that there is clear guidelines for those medical practitioners as to how they would come to that conclusion, that there hasn't been any, or knowingly no, coercion or pressure.
Now, correct me if I'm wrong here. What you've said there is coercion is prior to. You talk about coercion prior to the person, kind of assisted dying, but surely the offence, if that person actually goes through with assisted dying and then it's found later on to have been coercion, yeah, sure, that's the offence, because if it's caught prior, then it would prevent the person from dying in the first place. Surely the offence is post death.
Is it making the declarations?
No, I think post-death it would potentially be considered under homicide, because it would be take it out with the realms of the bill. Yeah. So there is, my understanding of the bill is there's an offence of coercion in the process. So there could somebody be reported for coercion if it's raised by one of the medical practitioners in terms of part of the process at any stage in terms of the declarations. But if it was raised post and the person had died, then that would, in our view, potentially take that out with the process and open or the opportunity for an investigation in terms of homicide.
Yes, I think that's right. I mean, the stated offence relates to either the first or the second declaration, so it could come to light pre or post-death, effectively. And as Laura says, I think it would be considered potentially in a slightly different way.
Right, okay. So in that case, if we talk about coercion, there's also the potential for coercion to prevent somebody from an assisted dying. Is that an offence?
My understanding of this bill is it's not an offence within this bill in terms of coercion. I think in some jurisdictions there is an offence, potentially Australia, but not as the bill currently proposes.
I think that's right. I think they have to be coerced into making either a first or a second declaration in terms of the process for the offence in the bill.
I think we're unanimous on that. I think the point in which somebody's coerced, it's coerced into the positive act of making a declaration either at the stage 1 or the latter second declaration. That in itself is an offence under this bill. Yeah. Had they gone on to complete, my understanding is that we would be completing a homicide investigation and everything that goes along with that, which is why the clarity is really important.
I think, can I ask, there's a difference between what the UK Parliament have passed to what this bill currently contains. I think the UK Parliament contains a wider range of offences than the bill as is currently drafted in Scotland. I don't know if your thoughts on that. Should we be closer to what UK are looking at, or does that cause us more issues?
So, having a look at the England and Wales bill, that's a 3-stage process. So it's very, very similar to the proposal in the bill here. But the 3rd stage, in terms of the process with the High Court, is a distinctly separate aspect. The offences that they have in sort of sections 26 and 27, 26 is very similar to what we have in the bill here around that coercion or pressure, but it also introduces an element of dishonesty, that somebody has to behave with a mindset that is seeking to achieve that ends. And then the section 27 offences are very much around the roles of the registered medical practitioners, and if they then create a false document or a false statement in order for that person to end their life. So that I would say they're additional, but I do think for us, anything beyond the act where the person's life is ended, for us would be culpable homicide, at the very least, possibly murder. And that would be investigated under Crown direction, is my understanding, in that way. So whether we need specific legislation in the bill or in Scotland, we can rely on the culpable homicide and murder aspects of the investigation.
Time for a small. Just finally there around the definitions of the bill, for example, relating to what qualifies as a terminal illness and the act of self-administration, which is another area which has been quite thoroughly looked at in our evidence here about what we mean by self-administration, because currently as the bill is drafted, it's we are assuming ingestion, of some concoction. But of course, we've also looked at, what it would mean is, if around human rights for somebody who can't swallow and maybe have to go down another route. And in relation to that, one of the things I'm considering is if something goes wrong, what's the legal requirement of the medical professional who's there at the time? Do they have to step in and save the person's life, or that's a grey area that worries me. Yeah, Mr. Johnson, yeah, okay.
So it is again, I think, something we're agreed on. Section 15, subsection 5. That is where the medical practitioner providing the administration of the substance has to be present. And then in the very next section, it says that person can leave the room. And for me, there's an ambiguity there, that if somebody is expected then to ingest or administer the substance to themselves, presence in section 5, but you can leave the room in section 6. So it just needs to be clearer for me. In section 5, it does say that you would provide the substance, you would remain present until the person had ended their life. But it seems to me, and my reading of it, I think it's a shared reading, is that in subsection 6, having provided the substance, you may then leave. whether there's external observation of what takes place in the room, but as to that person then does go on to self-administer, or whether there's other people present in the room that might intervene or do something. There's a nature of ambiguity between Section 5 and 6 that, from a policing perspective and an investigative perspective, we would seek that to be clarified, because it would be terrible to think that somebody did change their mind but somebody else in the room administered on their behalf. It feels very frail as a piece of legislation at that point.
I think we can envisage that, you know, it's very personal, but people take comfort at times of being with loved ones when they die. So it's the section in terms of clarity around whether the medical person would be there, or there's a situation where the medical person would not be there but family members would be in the room when the self-administration takes place, and that can or may have a bearing in terms of criminal investigation. So I think it's back to our point around just clarity in terms of for COPFS and for the police in terms of considering the legislation about what actually is going to be required in terms of that process. I think you also touched on the definition of terminal illness, and we're not medical professionals, but again, in terms of medical practitioners having to determine that, I think the more clarity that we can have in terms of the breadth of any definition of terminal illness, which we know is not an easy definition to make, would be helpful for us in terms of investigation.
Yeah, I would agree with that. From a death investigation perspective, it's clarity that we'd really need. I referred to earlier on the process of considering each step in the process to ensure that it was lawfully complied with, and that process is certainly aided by clarity in terms of the definitions and the process steps. And I would reiterate the same point around the provision of assistance. It's clear the medical practitioner has to be there, although not necessarily in the same room. The provisions are silent on who else can be there, and that would create the potential scenario where the medical practitioner isn't in the room at the point when the substance is administered, but another party might be, and that obviously raises concerns in terms of us having a full understanding of the circumstances in which the substance was administered and by whom.
Thank you. Thank you, Ciara.
And Sandra Skohani.
Thank you. I'm just declaring interest as a practising NHS GP and also chair the Medical Advisory Group. Good morning, panel. I've got just a couple of questions just around this topic. The first around coercion, and certainly you mentioned after the event. So in a scenario where somebody decides that they want to go through with the assisted death, and you have a very supportive family member, which you'd hope you'd have, and then later on, after the event, another family member, maybe a distant cousin, that says, actually, I'm against the idea of assisted dying, and you have clearly coerced because you've been so supportive. How can you unpick that? And would you be open to many complaints coming through?
I think that's a really good articulation, if you like, of the worry that I have, that exactly that, families are extended, they're distant, and for us, I think the legislation is very clear about what it's intending for that person to make a decision about their own time of death, as it were. For us, if that person then came along, clearly we would consult with the Crown, but if we then had to begin an investigation that ostensibly would be around murder or culpable homicide, what you have turning up then is a full police investigation into a family group that is already probably traumatised by the passing of a loved one. And then an investigation around the circumstances that have led to somebody believing it was coerced or not, which for me is why we're seeking that clarity around how does the two medical practitioners come to the point where they can sign their statements and say, we believe, or no knowing coercion or pressure has been put on that person, and that would stand scrutiny in the Crown and for us, so that under those circumstances it wouldn't be referred in terms of the police conducting an investigation. They would have the full protection of the law that says, actually, you've followed the assisted dying bill. There is a clear set of guidance to the medical practitioners as how you come to that determination of no coercion or no pressure, and at that point that is if you like, a clear-cut ending to that process. we do have concerns. Without that clarity, you will end up in those really challenging situations with a full police investigation into circumstances that the bill potentially could have addressed before being enacted.
Thank you. And I have another question, and this is sort of going to be extremely rare, the idea of this occurring. But if somebody comes and falsifies the idea that they have a terminal illness and ends up having an assisted death, where do we stand on that?
It's very difficult, and I'm not sure we can or should get into going down hypothetical situations in terms of how the bill would be applied. But, and it's difficult to imagine a situation where the individual might be able to fake a terminal illness. But in terms of the prosecution of somebody assisting, we would need to go through the process in terms of investigation to determine whether it sat within the bill, notwithstanding there had been some falsehood. But yeah, it would be subject to an investigation.
Yeah, and I would go back to what I described earlier on, is that initial assessment as to whether the process has been lawfully complied with. Now, it might not have been lawfully complied with for whatever reason, but that doesn't necessarily mean that there's criminal conduct underlying. It would just simply mean that the safeguards or the protection around criminal liability is no longer there, and we would have to consider the individual facts and circumstances and any potential offences.
And I think in the declarations of the two registered medical practitioners, they declare, you know, in terms of the wording of the bill, I am of the opinion that they are terminally ill. I think what we're suggesting is the legislation in England and Wales would create an offence if that person then falsifies a document. You know, I don't know how doctors, I'm not a doctor, I'm a police officer, but if a registered medical practitioner with their knowledge of medicine came and said, I am of the opinion and I believe that that person is terminally ill, that would have to stand on its own grounds. And take it forward. It wouldn't just be for the person to declare that they have a medical illness. There are two practitioners that then certify that view. And so long as that's conducted, I think we would be in that territory of, as I say, in England and Wales, there's legislation that if a doctor falsifies those statements, then there's a clear offence within their bill. There's not an offence within the bill in Scotland. We would be straight into culpable and probably murder, because it would, especially if that was the person providing the substance. And we'd have to investigate through motivation, etc., etc.
Thank you.
Elena Whittam.
Thanks, Convener, and good morning to the panel. Just to continue on the issue around about death investigations, so death investigations as it stands currently, and also should this bill pass into law, and the interaction with Article 2 in the European Convention on Human Rights. And I'm wondering, have any of the witnesses had a chance to consider what level of investigation might be appropriate in assisted deaths? For example, would you foresee a requirement for all assisted deaths to be reported to the Crown Office and for those involved to be interviewed in every case?
I'm happy to answer that one. The Lord Advocate, as you'll be aware, has responsibility in Scotland for the systems of prosecution and the investigation of death, and she makes decisions in relation to those functions independently of any other person. I'm currently the head of the Scottish Fatalities Investigation Unit, and I've got operational day-to-day responsibility for the investigation of all certain suspicious and unexplained deaths on behalf of the Lord Advocate and in the public interest. And deaths reported to us are investigated rigorously, respectfully and compassionately. A death investigation has a number of purposes within Scotland. I think most obviously it's in order to identify whether there's any criminality associated with the death. But beyond that, there are wider purposes for a death investigation. First and foremost, it's about ensuring that every death in Scotland has a medically certified cause of death. It's also about ensuring that bereaved relatives have an understanding of the circumstances in which their loved ones died and answering any concerns that they might have. And it's also about identifying any lessons that can be learned for the future in order to prevent similar deaths occurring. The nature and the extent of any investigation really will be dependent upon the facts and the circumstances in each reported case. We do take a rigorous approach to death investigation, but it is proportionate to the circumstances. We receive between 13,000 and 15,000 reported deaths every year from either from Police Scotland or from medical practitioners. There's current guidance, as you may be aware, that's issued to medical practitioners on the deaths that are required to be reported to the Procurator Fiscal. That can include deaths where the medical practitioner is unable to certify for whatever reason, where they have particular concerns around the circumstances of death, and there are also mandatory categories of death that require to be reported, and one of those, broadly speaking, relates to unnatural death. So I can't, it's ultimately a matter for the Lord Advocate whether or not that guidance would be changed, and I can't commit to a position on her behalf today, but I would anticipate that it's likely, were these provisions to come into force, that deaths in relation to the assisted dying process would require to be reported to the Procurator Fiscal as a mandatory category of reportable death.
Okay, and just further to that, do you think it would be worth considering whether we should establish an independent review panel with investigatory powers with regards to assisted dying cases?
Well, deaths are already investigated independently by the Crown Office and Procurator Fiscal Service on behalf of the Lord Advocate, and that would already bring that degree of independent scrutiny around the circumstances of the death, and that's both in relation to the potential for criminality, but beyond that, in terms of a wider death investigation purpose, to see whether there are systemic issues or issues of public concern that require further investigation or indeed fatal accident inquiry in the public interest. So I think that is already there in independent terms. Okay,
so at this point in time, should these provisions come into force under current law and the way that it's set up with the Lord Advocate having that overarching role, you don't foresee at this point that there's any requirement to set up a different body that's actually going to be set up just to deal with assisted deaths, that we have enough provision currently in Scotland to actually deal with it?
Well, it depends on the purposes that if you're talking about data collection, data analysis, that's probably to be carried out by a separate body. I mean, the functions of the Lord Advocate here are clear in relation to the purposes I've already described, and I don't think anything in the provisions of the bill as it stands would impact upon the Lord Advocate's overall responsibility for the investigation of death.
Okay, and just finally from me, there have been, over the years, I guess, families and individuals who perhaps feel that their Article 2 rights are maybe not realised with the current setup of death investigations that we have in Scotland. Do you think that currently there is sufficient public scrutiny and involvement of next of kin when it comes to death investigations?
But we do involve bereaved relatives in death investigations from the earliest possible stage. As I said before, we have between 13,000 and 15,000 deaths reported every year, and the vast majority of those deaths, we complete our involvement relatively quickly and involving bereaved relatives. So at the moment, for deaths reported to us that doesn't require any investigation, we are concluding our involvement in 98% of cases within 6 weeks. For deaths that do require a degree of investigation, we're currently concluding our involvement within 12 weeks in over 70% of the cases, and that involves explaining the outcome to the bereaved relatives and addressing any particular concerns that they have.
Thank you.
David Torrance.
Thank you, Convener. Good morning to witnesses. Do witnesses have any views on whether a monitoring and review process in the bill are sufficient, and particularly from a human rights compliance or law enforcement perspective? And do you have any suggestions how it could be improved?
I mean, I don't think I've got much to add to my previous answer. To be honest, I mean, I think it's a matter for Parliament whether there requires to be enhanced monitoring provisions in force. The Lord Advocate's responsibility will be there regardless, and I think there will be a public interest in ensuring that there's an independent degree of investigation and scrutiny around the circumstances of each assisted death.
The bill stipulates that an individual's terminal illness would be recorded as a cause of death on the death certificate, as opposed to ingestion of a lethal substance associated with assisted dying. Do witnesses have any concerns about how this might impact on a death investigation process?
I don't think it would impact on a death investigation process. It wouldn't affect the way we approach the investigation. However, in normal circumstances, I would observe that a medically certified cause of death is usually to the best of the knowledge and belief of the medical practitioner who's certifying death. So these provisions would signify a departure from that. It's probably of most relevance to data collection on a national basis, and obviously the Death Certification Review Service perform that function, and it might be something that the committee will want to query with DCRS.
No further question.
Okay. Gillian Mackay.
Thanks, Convener, and good morning to the panel. Do you foresee a risk of confusion between the different eligibility criteria for assisted dying in different parts of the UK? Is there an associated risk that this will make law enforcement more complex? And if so, what do you believe should be done to address this? And if I could come to Steve first. Unbelievably.
Thank you. Yeah, I've probably already articulated that there are some differences in terms of the application of the law. I suppose from a selfish perspective, if this is the law of the land and this is the way it operates in Scotland, I don't have any concerns other than the ones that we've raised around the nature of the eligibility. I suppose if I do, it would probably be more general terms. For me, using the UK as an example, the England and Wales seems to be a three-step process with a High Court process. I suppose my fear is, and it's again, there's a piece of terminology that is right at the start around eligibility, that ordinarily somebody would have to live in Scotland for a year before they are able to access the bill. I'm not sure what ordinarily means. Could somebody not go through the process in England and Wales because it's 3 stages, it's slightly different, there's a High Court process, but could choose to come to Scotland and access that? So how long does somebody have to be in Scotland, and what does ordinarily mean? Because what I wouldn't want to see is Scotland becoming the destination of choice for people to come to use the powers that we have to end their lives rather than the relative powers in their own country, because that potentially increases the burden on us for investigations. And probably people outside of our jurisdiction, that lack of clarity and people challenging the process, which would then render us having to do investigations that would have to span a person using the bill in Scotland, but potentially most of their relatives, loved ones being in England and Wales, just as an example. So that difference there and the ordinary. And I suppose the other one is in relation to the age. So mindful of the United Nations Convention on the Rights of the Child, that legislation is fairly clear and unambiguous. You know, you're a child until the age of 18. The bill offers the point that from 16 you are considered to be an adult. And again, which is it? And which is the one that you would want me as law enforcement to look at? Because clearly if the person is 17, under one convention, they're a child and would have certain parental rights in terms of support of that child. But according to the bill, a 16-year-old can determine that they want to move forward with a bill that seeks to end their life. And that's different. And I would seek that clarity that you know, are they considered by the bill an adult at 16? And if so, that's not consistent with lots of other pieces of legislation in Scotland, and would need real clear guidance on that and guidelines around what is the role of parents of children, if it is deemed by Parliament that you did want it to be available to children, as defined by UNCRC. So that it's those things that create a disparity between ourselves and other jurisdictions that might make Scotland an attractive place to come to access the bill, if that makes sense.
Yep, absolutely does. Did anybody else want to come in on any of those points specifically before I move on?
We have discussed and we had made similar observations around the age and the tension with the UNCRC definition of a child, which came into force in July of this year, and also around the terminology of ordinarily resident and what that means, and some clarity around that in terms of the position in England and Wales and the position in Scotland.
Useful, thank you. How best do you believe Scotland's legislation should ensure clarity and minimise complications for individuals and families navigating the different legal frameworks on assisted dying across the UK to make sure that they don't fall foul of any rules, as Steve has just said? I wonder, Laura, if you had any comments on that in particular, how we can make it easy for families to navigate so they don't end up coming under investigation by either the police or ending up within COPFS as well.
Yeah, I mean, I think I would just follow on from Andy's point that deaths investigations in Scotland are undertaken rigorously and compassionately. And it's not about, in terms of an investigation, trying to, I suppose, trip people up in terms of them not following, if they're doing their best endeavours to follow the process. So it goes back to our point about ultimately it's a matter for parliamentarians to determine what what it says in the bill. But for the purpose of investigation and consideration, the better clarity that people who are going to want to follow this process have to ensure that they are following the right steps, they're following the right process, that both for family members, friends and for medical practitioners, that they are absolutely clear in terms of the process. And then for us, when that death is reported, that will mean that there's a limited amount of deaths investigation that require to be carried out to ensure that families can deal with their loss in a compassionate way and investigations can be closed. The risk of not having that clarity is that it just potentially opens more up to investigation.
Does anyone else want to come in on that?
No, I entirely agree with that. I mean, I think going back to the point I made about just the proportionate approach that we would take to death investigation, difficult to get into hypothetical scenarios here, but I think it's possible to imagine a scenario where our involvement in an investigation of this type would be relatively brief, where it was clear, for example, that the process steps had been followed throughout and there was no concerns being expressed by any party involved.
I think that the point Laura makes is that guidance is not only going to be exceedingly useful for the people directly involved in this, but that wider, I think back to the doctor's point around that wider family, the perhaps displaced family, that can, even if they don't access it through people who are involved in the process, but they can see that, it's open to the public, so there's absolute clarity around the steps, the terminology, the language that's used, and in terms of how that's interpreted by the law, and we'd find that useful.
That's great. Thanks, Convener.
Brian Little.
Thank you. I kind of tried to cover this a bit before, and it's something that's buzzing around in my head. Around, does the bill protect the health? Is there enough protection within the bill for the healthcare professional? I think the question around if during the process of taking, the substance, something goes wrong, what then becomes the legal responsibility of the healthcare professional? Do they step in? Are they liable for prosecution if they step in and save the person, or are they under pressure the other way if they don't step in and save the person? Does the bill clarify that enough to protect the healthcare professional?
I think our observation, and again it's difficult in terms of hypotheticals, is that there should be some clarity around that. I don't see from the proposal of the bill there would be an offence if a medical practitioner, if for some reason something went wrong and the medical practitioner required to step in. I can't think or consider what an offence may be there. But again, it would be far better for medical practitioners to have clarity. We have dealt with cases, obviously, where there are do not resuscitate or plans in place that are clear from those involved. But some clarity around that whole process in terms of what happens in terms of the self-administration, I think would be helpful in terms of the bill.
Yeah, I completely agree with that. And I just, again, go back to the point I made earlier on. I mean, it's possible to have a process that's not considered to be lawful for whatever reason, but that doesn't automatically mean that a criminal offence has been committed. The circumstances would have to be considered carefully, and it's difficult to get into those hypothetical scenarios, I think, at the moment.
And I think you want that clear guidelines as well. I'm not sure how it works in terms of the substance that people administer, but everything works in a different way and may present differently. And what you wouldn't want is people in the room reacting to something that they're seeing that is predictable. I'm perhaps not explaining myself very well, but if in the manner of dying, people present in a certain way that people might think that's distress or that's this, but that's perfectly normal. That is how this substance works. We need to make sure suggest that you need guidance that means the people that are in that room, if there are anybody else in the room with the person, that they're aware of that and not reacting to what they see in front of them. I don't know whether I've explained that very well, but you would seek to limit the people for the desire to intervene rather than leave it to happen chance.
Okay, thank you.
Sanders Gohani.
Thank you. So I just want to look a little bit more at the interaction across the UK. There's no guarantee that either bill will pass. So if the bill in Scotland passes but not in England, then would you foresee a potential problem with families who are supporting ordinary resident Scots from England getting into trouble due to the law not changing in England?
Again, it's very difficult to see. I think from our perspective, as long as the terms of the bill as proposed were being followed by the family, by the medical practitioners, and then it would fall within the scope of the bill, and that would again limit the investigation. I think Steve's point around clarity, that might mean that you have people moving to Scotland for a period to allow themselves to have the opportunity to use provisions in the bill, but that would still sit within the terms of the bill as it's currently drafted.
I suppose it comes back to one of the differences in the terminology. In England and Wales, it's, I think the terminal illness will last a period of 6 months. So, if you like, south of the border, timelines are quite tight, and if they can't access it, that's why I asked the question about ordinarily resident. It talks about a year in the bill, but would people consider less time than that? So I think we'd need the clarity, but I don't foresee any problems if you know, given the caveats of our sort of feedback around the bill, and it's clear, and the guidance is clear, and the process is clear. I think any involvement from law enforcement, so long as those criteria are met, for me, I certainly wouldn't anticipate that the vast majority of these would even be reported to the police by the Crown or by the hospitals or GPs that are administering it. It would be something between them and the Crown, and the police's involvement would be minimal.
And this might be a very stupid question, but I assume if you did have a complaint and you were an English resident with a Scottish family member, you would make the complaint in Scotland rather than in England?
Yeah, I think, if there was a complaint about the process in Scotland for someone resident in Scotland where we had jurisdiction, then clearly we'd do that. If there's a complaint from somebody about something that happened in England and Wales, we'd facilitate that and find out who the appropriate jurisdiction is of the forces in England and Wales to make that complaint, because it would be for them.
Okay. Thank you very much.
Thank you. Can I thank the panel members for their attendance today? I think the committee's found your evidence very helpful in our scrutiny of the bill at stage 1, and I'll briefly suspend this meeting to change over witnesses. We now continue our scrutiny of the Assisted Dying for Terminally Ill Adults Scotland Bill, taking evidence from the Cabinet Secretary for Health and Social Care and supporting officials. And I welcome to the committee Neil Gray, Cabinet Secretary for Health and Social Care, Nikki Crossan, Assisted Dying Shadow Bill Team Leader, Ailsa Garland, Principal Legal Officer, Neil Ritchie, Palliative Care Unit Head, and Joe Swanson, Healthcare Quality and Improvement Divisional Head from the Scottish Government. And before we move on to questions, Cabinet Secretary, I believe that you would like to make a brief opening statement.
Very briefly, and thank you, Convener, and good morning, colleagues. Thank you very much indeed for your invitation to give evidence to the committee on what is, as I'm sure you have found throughout your evidence gathering, a very sensitive and emotive topic. As I outlined in my memorandum to this committee in September, the Government is taking a neutral position on Liam MacArthur's bill at this stage, and it is for Parliament to decide whether it supports the general principles behind the bill. Given this, I'm not in a position to comment on assisted dying in principle or on the individual provisions within the bill, but beyond what I've already outlined in the memorandum. It is important that, as lead minister on this bill, both myself and the Government remain neutral while Parliament carries out its scrutiny. However, my officials and I have been following closely the evidence gathered by yourselves over the past few months. The work you have been doing and the evidence brought forward by stakeholders will play an important role in supporting our decision-making around any amendments that we might wish to bring forward to the provisions of the bill should it pass Stage 1. And I would also look forward to reading the Stage 1 report from this committee when it is published. This is a hugely complex, emotive, contentious topic, and it remains my hope that regardless of our personal views, we as MSPs will be able to work together across parties to ensure that the debate continues to be handled with the sensitivity it requires and deserves. So I'm very grateful to the committee for the respectful way that it's handled its scrutiny thus far, and I thank you again for inviting me to give evidence on this important issue. Thank you.
Thank you very much, Cabinet Secretary. And we will move straight to questions. And Gillian Mackay.
Thanks, Convener, and good morning to the panel. Could the Cabinet Secretary expand on the Scottish Government's concerns around legislative competence? For clarity, do you regard the bill to be out with legislative competence to the Scottish Parliament, or is the Scottish Government's concern that aspects of the bill may not be possible to implement within the current restrictions on legislative competence?
Thank you, Ms Mackay. Thank you, Convener. I cannot really say much more than I've already said in my memorandum to the committee. However, to summarise the Government's views, we believe that the bill in its current form is outside the legislative competence of the Scottish Parliament. In particular, we believe that Section 15(8), which gives power to the Scottish Ministers to specify in regulations a drug or other substance as an approved substance to be provided to the terminally ill adult to end their low in life, appears to relate to the reserved matter of medicines, medical supplies and poisons, Section J4 of the Section 5 of Schedule 5 of the Scotland Act 1998. Given that the bill represents a novel and fundamental shift in the role of medical practitioners and the regulatory framework in which they operate, from protecting or enhancing patients' lives to assisting in termination of life, we also have concerns that some of the other provisions in the bill may relate to the reserved matter of regulation of health professionals. Again, Section G2, Schedule 5 of the Scotland Act 98. That is a confirmation of the position I set out in the memorandum.
Thanks, Cabinet Secretary. The member in charge of the bill has identified some routes, including some orders within the Scotland Act, which could be used to deal with some of the competence issues. If the bill was to pass at Stage 1, will the Scottish Government commit to taking forward discussions with the UK Government on these matters?
Of course, again, I thank Ms Mackay, and I note the comments that she makes around Mr MacArthur's endeavours. Of course, it's for Parliament to decide upon Stage 1. We would then need to consider our position on the basis of what we've set out prior to Stage 1 and what I set out in the memorandum, and we would explore whatever opportunities there were should the bill pass Stage 1.
That's great. Thanks, Convener.
Thank you. And Elena Whittam.
Convener, good morning to the panel. Good morning, Cabinet Secretary. I'm interested in pursuing some questions around about human rights, specifically in relation to the European Convention on Human Rights. So for that, I'm looking at Article 2, which is the right to life, Article 8, the right to respect for private life, and Article 14, prohibition of discrimination. So I'll frame a few questions round about those. The first question I've got is what advice, if any, has the Scottish Government sought on the bill's compliance with the ECHR and the likelihood of any legal challenge that could arise should it be passed?
So these are considerations that I note. First of all, thank Ms Whitton for her question. I note that these are questions that were considered with your previous panel, particularly around prosecution policy and investigations. Obviously, we have assessed the equality impact assessment that Mr MacArthur has put forward, and we'd be looking, depending on the consideration that the committee gives to these particular questions, whether further work would be required post stage 1, but at this stage I would rest there.
And further on the context of human rights, what's the Scottish Government's view on whether the bill contains sufficient protections in relation to vulnerable groups? If there are any concerns in this regard, what could be done to address them?
Again, this would be for the member, in this case Mr MacArthur, to consider. We haven't taken a policy position on that issue. We don't have a policy position on the elements contained within the bill, so these would be considerations we would need to take on the basis of the evidence that's been gathered by the committee and to determine should the bill pass stage 1. Okay,
and I'll ask the question, but I'm not sure whether you're going to be able to answer the question that I'm asking. But similarly, to what extent do you believe in that the process in the bill is compliant with the prohibition of discrimination contained in the ECHR? And if not, would you like to see this addressed?
So again, I will, through the course of this session, try to be as helpful as possible. I hope you'll note that, in response to Ms Mackay, I tried to give as expansive an answer as I could. I can't say anything further beyond what I've already set out and what's in the the policy memorandum that I set out to the committee.
Okay, thank you.
David Torrance.
Thank you, Convener. Good morning, Cabinet Secretary, and good morning to witnesses. Has the Scottish Government undertaken its own estimate of costs arising from staff time, and can you detail how these differ from those set out in the financial memorandum?
So we detailed, I thank Mr Torrance for the question, we did query the financial memorandum in the policy memorandum that I set out. I note that Mr MacArthur has done some further work off the back of that. However, we do have concern that the costs that have been associated with the financial memorandum as it's been set out do not go as far as what we believe could end up being the cost. And it may well be that it would be a requirement for this bill to have a financial memorandum associated with it.
What is the views of the Scottish Government on the adequacy of the training expectations set out in the bill and the financial memorandum?
I think I've set out in the policy memorandum the elements around the potential costs, the particular issue that Mr Torrance raises around training costs. If we were to assume that half of all doctors would undergo training and that the training time is around 7 hours, as is suggested in Mr MacArthur's memorandum, that would give a total cost of just over £6 million for training time, which hasn't been factored. Again, these are for Parliament to consider, these are for the committee to consider going forward. It's something that we've noted as part of our memorandum to the committee for you to consider.
No further questions.
Can I just, and before I ask my question, I'll put on record that I hold a bank nurse contract with Great Glasgow and Clyde NHS. Can I just ask for a wee point of clarity there? When you're talking about the training costs there, Cabinet Secretary, are you talking about training costs for medical staff? Or are you talking about training costs for all healthcare staff? Because I'm anticipating that there would be pharmacists involved in this, that there would be nursing staff involved in it, and perhaps other AHPs.
The assumption that I've given you is for doctors.
For doctors only. So for the entirety of healthcare staff who may be involved in this, should the bill pass, then that cost would be anticipated to be greater.
I'm happy to bring Ms Crossan in to give further detail, but obviously a lot of this would be dependent on the model that comes forward. And there are questions which I know the BMA have raised as to the model and how it is to be established. But the point that you raise is correct. I'll bring Ms Crossan in.
Thank you. So just to say that those are indicative costs, so we have based that on the assumption of, say, around half of doctors basically agreeing to participate in the process, because we understand that there are the conscientious objection clauses within the bill, so not all doctors would necessarily. So that's based on half.
Okay, that's great. Thank you very much for that clarity. Emma Harper.
Thanks, Convener. Just on that, so the cost of the education would be like initially, because then once it was established, then it would be built into registered nurse training programmes as well as medical training as well. So it would be an initial cost, but then it would be built into future training programmes.
Ms Harper's correct, yes.
Thank you. Brian Whittle.
Thank you. Good morning, Cabinet Secretary and to the rest of the panel. One of the main concerns around the bill have been around access to palliative care, and the concern that sort of 1 in 4 people are not getting access to appropriate palliative care as it currently stands, and that might influence their decision on whether they access assisted dying. And I wonder, Cabinet Secretary, from your perception of the Scottish Government's estimation, is palliative care good enough at the moment, or are you concerned also that lack of access might have an impact on this bill?
I thank Mr Whittle for his question, and this is an area that clearly we do have extensive policy positioning upon. We've got a draft palliative care strategy that's just concluded its consultation phase. We'll be expecting to. We're currently considering the responses to those consultation, the consultation responses, and expect to be able to publish that draft strategy later this year. We've also, as you will have, Mr Whittle will have seen, put extensive additional funding into the health and social care services in general. So for the draft budget coming forward, 21.7 billion, and would obviously expect local boards to be ensuring that there is adequate palliative care provision available. And we have put forward a line within the bill, increased hospice care funding as part of the bill, and a proposal to align Agenda for Change pay conditions with hospice funding going forward, so that we can make sure that there is adequate palliative care in place. I'm very grateful to the people, whether in the NHS, whether in the hospice sector, community and social care, general practice, that provide extensive palliative care support, whether in hospital, whether in someone's home, whether in a care home or in a hospice. And the tireless efforts that they go to in order to do so receive my extensive thanks. And I also think we in Parliament have got a role to play to ensure that there is help for people to understand what palliative care is, what it is not, and the interaction or otherwise that there is with this particular bill, to make sure that some of the stigma that surrounds palliative care and around dying are addressed. And with that in mind, obviously we'll look to make sure that we're doing everything possible to provide the palliative care support that people need and expect.
Thank you for that, Cabinet Secretary. Appreciate that answer. So, presumably then, given what you've just alluded to there, if the bill is amended to include, mandatory access to palliative care for anybody considering, assisted dying, i.e., that must be offered at the same time. Presumably then, if the bill is amended, the government would support a financial resolution to make sure that the bill could go ahead as amended.
That would obviously be a financial undertaking, and something we would need to consider should that amendment or the amendment of that nature comes forward, it would be for others to determine whether it was within the scope of this particular bill as to whether an amendment like that could come forward. But I recognise the work of the likes of Miles Briggs has been doing, and we are obviously, as part of the strategy that we're taking forward, considering how we can make sure that palliative care support is as extensive and equitable as possible. The work that we're doing in that vein, as well as supporting our hospice sector and our health and social care services, would be with the aim of ensuring that there is that availability of palliative care at the point of need.
But you would recognise, you know, as many have said, and the evidence we've heard from a number of witnesses, that the concern is around those who potentially don't have access to palliative care, or don't get access to that palliative care, pushes them down the route of assisted dying unnecessarily. I mean, would you share that concern?
I haven't had that concern expressed to me. I haven't had that concern suggested as a motivation behind someone supporting an assisted dying bill or otherwise. What we will do is continue to make the provision of palliative care available as universally and equitably as we possibly can. And I believe in the steps that we've taken through the proposed budget, we can see a continued improvement in that position, both in terms of the direct funding we're seeking to provide to hospices who have a particular challenge, as do many other social care providers, with the likes of the employer national insurance contributions increase that are coming down the tracks. We're looking to do what we can to support those organisations as best we can, whilst obviously wanting to see the UK government resolve this matter at source. But the funding that we also provide to our health and social care partnerships and our health boards is for them to direct where that funding then goes based on the demand that is placed upon them, and in this case on palliative care services. And we'll continue to work with them to ensure that that can be provided as universally and equitably as possible.
I think one of the big wins, if that's the word I'm looking for here in terms of this bill we brought forward, is shining a light on palliative care and the need for equitable palliative care across the country. But I can ask Cabinet Secretary, if you look back at some of the evidence we've heard, palliative care is that concern around palliative care and the potential for assisted dying for some people to look at for assisted dying because of inadequate palliative care in their particular instance. I would ask you to have a look at that, because that for me is a big concern in terms of, you know, we would like to think, I'm sure you would agree with me here, that everybody, you know, who if this bill passes, who wish to consider assisted dying, would also have access to palliative care, and that would be raised by a GP or whatever at that time, that is equitable.
Yes, I mean, I recognise that some may have raised that as a concern. I hope I've set out the steps that we're taking to try to address that being a concern. The draft strategy that's been consulted on currently, seeking to improve the position of palliative care, the steps that we're taking within the budget to fund our health boards and our hospices in order to maintain or expand provision. I think it's also important to stress that there is a belief wrongly held by some that palliative care is only for those who have a short time left to live. Palliative care can, in many cases, it should be offered from the time that a person is diagnosed with a serious or life-threatening condition, and it can help them to get the right support in place to better manage their symptoms, to think through the best treatment options going forward, taking account of what really matters to them, that really person-led approach that we want to see. And it can be offered alongside other treatments that aim to prolong their life. So this is really, it has to be bespoke, it has to be person-led in order to ensure that we are addressing the needs of people as they see them. It's not just for those at the end of life. And so I hope that provides additional clarity for the committee to consider as part of whether this is a factor in decision-making that's going forward.
Thank you, Keir.
Thank you. It's Sandesh Gohani.
Thank you. And just to declare my interest as a practising NHS GP and chair of the Medical Advisory Group. Good morning, Cabinet Secretary. Good morning, panel. I'd like to start by asking your opinion on the age in the bill of 16. Given the last panel we're talking about 16 or 18, and this is a debate that we've had throughout the evidence that we've taken, and what would your position be?
I thank Mr Gahani for his question. Good morning. I heard the evidence that was given earlier. I note the debate that is there and the points that were put across. I can't put forward a position for which I hope Mr Gahani will accept. I don't wish to in any way. This is for the committee and for Parliament to determine, as the lead minister for the bill, where the government is taking a neutral position. It's not for me to influence or in any way the consideration that people have.
If this bill were to pass at stage 1, would the government be speaking to the GMC and the Scottish GMC and also the UK-wide GMC about its position and how it could make sure that this bill is able to be used in a safe way for doctors, given the fact that you'd be open if you were to proceed to people sort of complaining about you with malicious intent?
Yes. Should the bill pass stage 1, there would be extensive discussions to be had with a number of stakeholders, and I would have a responsibility as Health Secretary to ensure I was taking matters forward in the interests of health and social care services and those people that interact with them. So the conversations such as those that Mr Gilhani set out, I think everyone would expect me to have.
Okay. And is there anything on the face of the bill that you or the government would like to see about how the service would operate?
I've noted some of the evidence that's been put forward. I understand the debates that are there, that are live, that the committee will be considering around the shape of any proposed service coming forward, or how it interacts with existing health services. It's for Parliament, it's for the committee to determine its stage 1 report, for Parliament to consider it, and my position will remain neutral until that has taken place. Okay.
Given your previous answers, you might not be able to answer some of my other questions, but I would like some comment about the relationship to the potential service model should the bill become law. So, for example, do you feel it should be a separate service within the NHS, or integrated within existing services?
Again, I'm trying to be as helpful as possible to Mr Gilhani and to the committee. I've set out in my opening statement that as lead minister for the bill, where the government is taking a neutral approach, it wouldn't be appropriate for me to comment on provisions within it. I note the evidence that has come forward, and I understand the debate that's there, and that is something that we will all have to consider should the bill pass stage 1.
My final question, do you feel that there should be a register for people who are trained to perform the assisted dying and willing to participate within it in a sort of an opt-in system?
I've again seen some of the evidence that there is from the likes of the BMA and some palliative care professionals in that space. I understand the perspectives that have been put across. It'll be for the committee to report, it'll be for Parliament to consider, and thereafter the government will take a firmer position on these topics.
Okay. Thank you.
Thank you. Before I move on to Carol Mochen, who joins us online, can I just go back a little bit for a point of clarity around about the financial memorandum? So with regards to the sort of training time, training costs that government has looked at in comparison to Mr MacArthur's financial memorandum, and Emma Harper's comments about that you would anticipate that if the bill were passed that there would be some pre-registration training that would replace the training that would be needed done given the bill coming. Would there be any scope then to factor in costings for updates, because what you learn pre-reg does not necessarily translate to something that you're doing in clinical practice 5, 10, 15 years down the line?
Be happy to take that one away, convener, and write back on the basis of that, and give you what I can in terms of the financial memorandum considerations.
That'd be great. Thank you very much, Cabinet Secretary. Carol Mochen.
Thank you, convener. Good morning, Cabinet Secretary. I wanted to ask just something around the ministerial powers. You may or may not be able to put anything on the record at this point, but just to give you the opportunity. The bill contains 10 delegated powers provisions, 9 regulating making powers and 1 power to issue guidance. And I just wondered at this stage if you had any comment, or the Scottish Government had any comment, if what they thought about the scope of the regulating making powers in the bill as it stands.
I thank Ms Mockin for her question, convener, and wish her good morning. I know that this is an area that has been looked at by the Regulatory Committee, and it's not something that I can comment on beyond what I've set out in the policy memorandum, which I hope Ms Mockin will understand.
No, that's absolutely fine. Thank you very much. Can I just ask, is there anything about what would be on the face of the bill that you'd be able to comment on at the moment, particularly around subordinate legislation?
Unfortunately not. Beyond what I have set out in the policy memorandum, I must maintain a strictly neutral position to allow committee for Parliament to assess the merits on the basis of what I believe will be a universally free vote, including within government. And my responsibilities as Health Secretary, as lead member for the bill, would particularly come in should the bill pass stage 1, and then there would be far more extensive dialogue and discussion and policy positions taken.
That's helpful. Thank you. Thank you, convener.
Thank you. I've got some final questions, Cabinet Secretary, and again, there may be issues here that you can or can't comment.
Helpful as possible, convener.
No, I appreciate that, and I think the committee understands that you've set out the government's position. Does the government have an opinion on the proposed 5-year review period of the legislation, or the suggestion that the bill should include a sunset clause?
Not at this stage, no.
Okay. And has Scottish Government come to any decision or any conclusion about whether an oversight body to monitor the function of the legislation, should the bill pass, should be convened?
Again, I understand that being a query and an area of interrogation for the committee, but it's not one that the government has taken a position on as yet.
Okay. And my final question is about section 17 of the bill, which would require the terminal illness involved is recorded as the cause of death on the death certificate, as opposed to the administration of an approved substance associated with assisted dying. I wonder if this is an area that perhaps government with NRS has perhaps looked at, about how that may or may not be recorded on a death certificate, given that this would deviate quite markedly from what is current practice, as we heard in the previous panel.
Yes, I heard the evidence coming forward this morning. It's not something that I've interacted with NRS on, and I'm not sure if that's something that you've explored with NRS, but it may be something to follow up on, and it's not something that as yet we have a position upon.
Okay. Can I thank sorry, Paul Sweeney. Apologies.
Sorry, convener. Appreciate the Cabinet Secretary and colleagues joining us. It was just a point of interest on an earlier matter you discussed with colleagues on legislative competence, and certainly the provisions set out by the member in charge as the potential remedies to that concern raised by the government. I just wondered if at this stage the government did have a view on a preferred remedy, even though it's hypothetical at this stage, of course.
Yeah, I thank Mr Sweeney for his question and understand his reasons behind it. We've set out in the policy memorandum our position in terms of legislative competence. I recognise that Mr MacArthur has sought to put forward options here, and clearly should the bill pass stage 1, then we would be looking at what options may work there, but at this stage there is nothing further for me to add.
Could the government perhaps address each of the options at this stage and just outline what they would maybe do, whether it's section 30, section 63, section 104, or is that premature at this stage, would you say?
For the government, yes. We've got nothing further to add in terms other than the position that we've set out around the fact that this is, we believe there are elements contained within the bill that would not pass legislative scrutiny, that are not within legislative competence for us to consider.
Okay, thank you.
Thank you. I'm not having an indication that there's any further questions from the committee, so can I thank you, Cabinet Secretary, for your attendance today and your officials. Next week, the committee will conclude its programme of oral evidence as part of its Stage 1 scrutiny of the Assisted Dying for Terminally Ill Adults Scotland Bill by taking evidence from the member in charge of the bill. And that concludes the public part of our meeting.